Hey, well, tonight I'm angry about surveillance, and legal surveillance is bad enough, but illegal surveillance is even worse. And just before we get to the main point, let me give you a brief history on surveillance and how we got to where we are. It used to be that the government required a search warrant to search you. This is the Fourth Amendment protection. But with cell phones, there was a long lag between the time we started using them and the time the court started recognizing what our rights were. Let's go back in history to see what our rights to privacy are. This was a landmark case, US versus Miller in 1976. And somebody who was actually accused of operating an illegal liquor still, he had his bank records seized. His name was Miller, obviously. And he argued in front of the Supreme Court that the bank did not have the right to release his records to the police without a warrant. The court held that indeed those bank records were the bank's records and he didn't have a right to have them protected. Let's move forward. This is Smith versus Maryland in 1979. And this is where the government actually put recording devices at the telephone company to record which numbers Smith called and received calls from. And the court ruled that indeed there was no expectation of privacy here because these were records from the phone company. The number that he had called, the numbers that called him were known to the phone company. It's like the third party doctrine. Once your information is given to a third party, you don't have any expectation of privacy anymore. And that's where things stood until this case, Carpenter versus US in 2018. And this was a case where robberies were taking place in, I think, Detroit, somewhere in Michigan. And the police were able to search cell phone location data to find out who had been in that location. They had captured one of the criminals, and after gaining access to his phone, they were able to search on all of his contacts and find people who were in the location where the robberies took place. The court ruled that this was not correct. You could not go on a fishing expedition of this type. Carpenter had the right to privacy. The irony here is that even though they ruled in his favor and they remanded it back to a lower court, the lower court ruled that the authorities had acted in good faith, as they invariably do, at least in the eyes of the Supreme Court, and Carpenter went to jail for 116 years. So we come to today, and what is the issue that makes this timely? It is this letter. This letter was sent from the Treasury Inspector General to Elizabeth Warren and Ron Wyden, explaining to them that they were going to be following up because the IRS has been tracking people without any warrant. The IRS has been buying location data from a company called Ventel, and Ventel has boasted that this data is not anonymized in any way. For example, if they can tell that there are 4 phones in a particular house, they can have a pretty good idea who those people are, especially if they can track them over time. This location data is being purchased. It's being purchased by the IRS among many, many other companies. This location data, you may not realize, is being spewed forth by your phone. When you download a free app to play a game or get the weather, you're giving that app your location information and you can be tracked. You know, they say that if you aren't paying for a product on your smartphone, that you are the product. And here we have this problem where even though there is vast amounts of legitimate surveillance taking place with this quote-unquote anonymized data, the fact is the IRS has been buying this location data without a warrant. Without a warrant. How is it that government agencies, and they admit that this was to track criminal suspects, how is it that government agencies are able to circumvent their warrant requirements? I mean, the IRS, you might remember years past, under Lewis Lerner, prosecuted, persecuted, investigated quote-unquote Tea Party activists, people who were advocating for a smaller government. The IRS was weaponized against them, and here they are buying location data without a warrant after it's been clearly established in Carpenter versus US that they have to get a warrant to get this information. They just ignore it. I mean, what do you do when government agencies just boldly and blithely and in your face just transgress the written law and dare you to do anything about it? I mean, the IRS has done it. They've admitted to doing it. They're finally being investigated. Legal surveillance is bad enough, but at least we know that we're being surveilled in exchange for getting free apps. The fact that government agencies are getting access to this data, buying this information without going through the court system is a travesty and needs to be stopped immediately. Hopefully this letter to Warren and Wyden indicates that we're on the right track. Please, let's put a stop to this stuff. Let's wake up.